Good morning. I'm Michelle Jacko, and I'm the managing partner of Jacko Law Group and CEO of Core Compliance in Legal Services. And today we're going to be speaking on a topic that I think is near and dear to just about everybody in this room, no matter if we're servicing clients or thinking about our own family members. What are the considerations for advisors with aging clients? And this presentation is going to be incredibly interactive, so I know there was a lot of quietness at the beginning. We're expecting audience participation because we're going to be talking about various hypothetical situations based on experiences that our panelists and some of our clients have experienced with servicing aging clients, which is a very complex issue. Today, it is my pleasure to be joined by some of the most knowledgeable people in the industry on this very topic. And to my right and to your left is Maria Chambers, who's with Klingenstein Fields Wealth Advisors. And to my other side, I'm joined by Sharon Bucafusco with Tradition Capital Management, and finally John Hadfield of USAA Investment Management Company. So in each of these hypotheticals we're going to be going through, they're going to be sharing with you their practical internal controls that they've developed in this very important area. But to really begin with, we want to spend about 5 minutes talking about the regulations that govern advisors in this area. And I'm going to be focusing on 4 in particular. And the first one I thought was one of the most meaningful, which is the National Senior Initiative. And this was a collaborative examination that was conducted by FINRA and the SEC, whereby they had in 2013 examined 44 broker-dealers. And in that study, what they found was that they looked at everything from security type to suitability to how we're training and registered representatives on this very issue of what we're dealing with, financial elder abuse as well as diminished capacity. And in that context, there was something that was very telling, and I almost equate this to, cybersecurity. When we're doing a cybersecurity plan, everybody generally developed a policy and procedure, and so folks are thinking about aging client issues. But what they might not be doing is developing what I'm going to call the incident response plan, okay? And what I mean by that is, if you actually are faced with this issue, who is it escalated to? And I think it was really telling because in this study, they found that only 13% of firms had escalated issues. And the other thing that really came out of this is, we're all about statistics and number and data when we're going back to the business unit. I'm just curious by a show of hands, how many of you have actually dealt with a financial exploitation issue at your firm with one of your clients? Okay. And what about a client that might have a potential diminished capacity? Okay. We're going to see everybody's hand go up in a very short term. And one of the reasons why is you can look at these Census Bureau statistics, okay? The aging population is just increasing every single day. And by 2040, there's going to be forecasted to be over 79 million people over age 65. So because of this, we have to be forward-thinking and consider what kind of safeguards can we implement today, all right? The second thing that really I think is telling is this SEC Investor Bulletin that came out on planning for how we're going to deal with diminished capacity and illness. And that was a 2015 release. And my first risk management tip for you for today is the SEC spends a lot of time coming out with these investor bulletins. And if you're not on their emailing list of when these are released, definitely get on there. This particular publication encouraged investors of here are the steps you need to take to protect yourselves in the case that you do have diminished capacity. And a lot of it was common sense, such as gathering your documents and making sure you have a durable power of attorney in place. But the one thing that really came out of this is that they talked about having an emergency contact. And I don't know about you, but there are certain clients that we deal with that have families where they might be, let's just say, dysfunctional. Perhaps they're not speaking with a son or daughter, or they don't trust even a significant other for certain aspects, and they want to keep those assets private. So in the case of diminished capacity, their emergency contact may not be a relative, or perhaps they don't have a son or a daughter, and there's nobody else to turn to. They're alone. So I think what really came of this release, and my risk management tip is, think about, this is something that the commission is giving as important information to investors. Is this something at account opening you should be turning over to your clients and handing it out to them and saying these are things that you need to think about? And it would actually open up the conversation of even comfortably speaking about diminished capacity. Next, there was an SEC speech on protecting investors from financial exploitation. And I think, what was really interesting about this particular thing is that it was this speech was done by a gentleman by the name of Rick Fleming. And Mary Jo White had appointed him as the SEC's first investor advocate, where that's what this office is in charge of doing. And he raised the question, he said, there's been a lot of dialogue about, the concerns of Regulation SP and the fallout that might occur, with regards to failure to follow instructions. Okay, if a client calls you and you say, okay, I'm going to not fulfill your request for withdrawal or transference of funds because I believe that there's diminished capacity, and you decide to delay that transaction, should there be repercussions on the investment advisor for not following that client's instruction? Okay, and his answer was, no, there should not be. Okay, our job as advisors is to be their advocate and to do what's in their best interest. And I think what was very interesting in coming of all that, we'll talk about later the NASA model rule and what that legislation looks like. Okay. In the meanwhile, what I want you to also think about from that speech is that because age is the leading cause of diminished capacity, in addition to all of those other things of thinking about, well, what should we do in the case where a client's giving us instruction whereby we are not sure if it's really in their best interest to follow, how else should we be communicating with our clients about these sensitive issues? And to that end, what FINRA had come up with in their various regulatory notices, 0743, 1537, and others, is that while FINRA may not be your regulator, they provided fantastic guidance on how to think about some of these senior issues and develop those internal controls. And it's for those reasons that we're referencing that, so that as you're developing your compliance program, if you want ideas on different controls and industry best practices, you have a place to turn to. Finally, and I think that this is really one of the most pivotal guidance, okay, and certainly the most controversial, is the NASA model rule, okay, to protect vulnerable adults. It was adopted in January of 2016. And what a lot of folks might not recognize, and I got this question this morning, is, NASA, that's the state regulators. Do we really need to be concerned about state regulation? And the reality is that while the majority of you would be federal registrants, okay, you're still doing business in these states. And so similar to Regulation SP considerations, and we know some of the toughest jurisdictions like Massachusetts and California, you still have to comply with what those rules are because you're doing business there. The same thing applies for how you're going to protect vulnerable adults. And in the NASA model rule, what was so interesting about this is that for the first time we've gotten crystal clear guidance on what, first of all, is defined to be an eligible vulnerable adult. And they're defining that as anyone of 65 years of age or older. When they came out with this release, they said, look, we've got 5 critical components that we want to cover, and we want investment advisors and broker-dealers to think about. If the state adopts the Model Act, it's voluntary. In most of the states that have adopted it, which are just a couple, there were material changes done to this. And so this is a foundational guideline that it's expected to be customized to the states and what they think is in the best interest of the investors within those borders. The first thing is that they said, if you believe that there's financial exploitation, you have an obligation to report this to Adult Protective Services as well as to law enforcement. The next thing is, and I didn't have this on the slide, is that there's an expectation that you appoint someone within the firm, certain delegated employees, that you have to have these escalation policies to, that you can report that there is the suspicion of being either diminished capacity or financial exploitation that's occurring. And what it would allow you to do is to reach out to an authorized third party. So I'm going to call those the emergency contacts, okay? If you suspect that there is a problem, okay, with one of your clients, that they're undergoing financial exploitation, for example. And this was the key. It's in the Model Act that you can delay disbursements for up to 15 days if you believe that there is what I would consider a reasonable belief that there could be financial exploitation that is occurring. And so there is an expectation in order to get that reasonable belief, you would do an internal review, you do your own investigation. In reporting this to Adult Protective Services, for example, if that agency comes back and they want more time to investigate this matter, they could delay it for an additional 10 days, so up to 25 days. Of course, you would be giving notification to the client that you're delaying the disbursement. And then finally, and this was a big thing, that there would be immunity granted to the investment advisors and broker-dealers for taking such actions. And that was on a civil basis, not a criminal basis. So if there was some monkey business going on or collaboration, there could be potential liability.
I think we got an addition.
Yes, I'm sorry. Yes, ma'am.
If this is adopted kind of state by state, are you going to be regulated by the state where you are located or the state where the client is located?
It's where the client is located. And so it is, as you can see, it's a very dynamic process. And I think with the model, we're going to come back to this, okay, throughout this presentation in some of the hypothetical situations we're going to be discussing. But we did want to remind you of two things, okay? Number one, you have your app to please ask us questions. Well, this panel is going to take questions throughout the session. And then, of course, if you do have any questions, just feel free to either raise your hand or I believe there's some cards that are being circulated, okay? So for our first hypothetical, Bernard is a seasoned financial advisor, and he serviced Dolores' account for over 25 years. Dolores is a 75-year-old widower. She's highly affluent and meets with Bernard every 4 months to help manage her portfolio and her income needs for her current lifestyle. In their last meeting, Dolores asked Bernard about an IPO opportunity that she heard about from her new friend, Arnold. After researching the opportunity, Bernard calls Dolores. She sounds disoriented and confused and cannot recall discussing the IPO opportunity. Bernard decides to visit Dolores at her home. When Dolores answers the door, she's disheveled as if she has not bathed in days. There is a stack of unpaid bills in the foyer, and she appears very defensive. So to begin this conversation, and before I turn the floor over to Maria, I have your first little surprise, okay? For those of you that are trivial, I was watching a TV show when writing this hypothetical. Can anybody name what these characters are based off of? Okay, you can think about, yes ma'am?
Westworld.
Correct. Give her your peppermint patties. Congratulations on that. Okay, Maria, that was your icebreaker for the audience. Okay, Maria, sincerely, this is a situation that I know several of our clients have experienced, and it's very sad and it's alarming. What should Bernard do in this case?
Well, first of all, good morning, everyone. I'm very thrilled to be speaking in front of you all and on behalf of the IAA for the first time. So in this scenario, I can share what I think is critical, which is the upfront communications that you have with your clients is the most critical component of having effective controls. And to that end, a couple of the things that we've undertaken as an example is to try to flesh out an emergency contact from the client that clearly sets out the various reasons and circumstances in which you would be getting together with an emergency contact and the type of information that you would be sharing. Making it clear that it's not a power of attorney, asking the client to sign it and to have an internal process to vet it on an ongoing basis so that it's maintained because emergency contacts can change. That being said, I think in this instance, maybe that is maybe premature. I think that we can have a conversation with the client and try to see if everything is okay. Because at this point, I'm not sure, provide them guidance and advice, but at this point, I'm not sure we're rising to the level of having to look into our procedures and seeing if we in fact have an emergency contact or if our standing contract allows us to even contact a third party.
I'm going to just take a pause. For those of you that are standing, there are many seats on the side if you want to come over. It's fine. Come on over. Maria, let me ask you this. In your firm, have you taken steps to educate your advisors on how to communicate with clients? This is such a sensitive issue.
Oh, absolutely. So what we did in 2016, we engaged in communications both with our employees as well as with our client base and just in general our client contacts. What we did with our employees is the IAA actually hosted this wonderful webinar that is available on the IAA website via recording at this point. But what I found really useful about the webinar is that it took a multidisciplinary approach to the issue. So they had caseworkers, life care caseworkers speaking to us, explaining what is diminished capacity, the types of behaviors that we should be on the lookout for. Separately, we had Michelle Jacko giving us the regulatory framework and the valuable information that is out there for us to try to determine what types of controls we should implement. And finally, we had a practitioner who actually had a team of probably about 20 individuals that were just dedicated to dealing with complaints. I believe the individual was from Wells Fargo. Quite a team assessing complaints with really solid policies and procedures for escalation and some really sound advice as to what we should consider. Among that is the consideration of what we do with our contracts. So we actually, and this is forward-looking, a wish list item, but we've already undertaken revising our advisory contract to include provisions that would protect us and our client and inform us overall with regard to what we will do so they're aware and that they can raise any questions proactively, but also letting them know that there's a potential that we may not act on a transaction in the event that we feel that there is financial exploitation going on.
And John, obviously at USAA, you've got an incredible team, and you're servicing clients in all different capacities that could be suffering from diminished capacity, that could even have post-traumatic stress syndrome. I mean, there's a lot of different scenarios other than just the appearance of someone, that could have the onset of Alzheimer's that's in this fact pattern. What are some of the things that you do there?
I think in this case, what we'd first do is ask questions. The reps would be trained to ask questions. Who's Arnold? Is he taking care of you? How's your health? Those types of things. And to document. For sure, document. And we emphasize that a lot. It's going to come into play as we go through the hypothetical and as we get deeper into it, we'll see the benefit of documenting. The other piece is inform the firm. Whether this case, as Maria had mentioned, whether this raises to a reporting at this point is questionable, but we think it's, at this point, we always want to communicate with others in the firm, whether that's a supervisor, whether that's our corporate fraud department, or the CCO. And I know all firms are going to have different, depending on the size of your firm, it might be your CCO, that might be your entire compliance department. At USAA, we have what's called, I suspect other large integrated financial service providers, we're going to have a shared service. And in USAA, that's our fraud department. And they assist with these questions of whether it rises to the point of being a reportable or do they think it's taken seriously. So I think those are the points that at this point, I'd have. I think the other piece, the one other piece is review the client documents that they have online, to Maria's point. Review what you have online. Is there a POA? Those types of things. The red flags are up at this point, right? So what do you do with those flags? You begin to communicate, and you decide whether it's reasonable to move from there.
Yeah, and to that, and I think one of the biggest questions that we often see is that folks want to know, you clearly have an escalation process in place.
Yeah.
So the question that I have is, where is that documented? Is it in the compliance manual? Is it in a separate SOP? How have you gone about memorializing that escalation process?
It's more or less it's a desktop procedure. There's a larger firm procedure that is very high level, but it's really a desktop procedure and piece of a training that all the reps can view regularly. So that's where we see it, and it's fairly specific, but it does. It's principled in nature in order for them to use judgment, and as we'll see moving along, that being reasonable in that judgment, having backup is important to be able to show, to satisfy yourselves and the regulator who may look at it later on, that it was a reasonable decision to move one way or another.
Okay, and the last question I have for John on this particular topic, okay, you're dealing with all different types of clients at USAA. What kind of training have you done to really help the advisors detect, gosh, this could be a potential situation? I mean, do you have a training program? Or how do you discuss this very sensitive issue?
Yeah, we do have a training module, and based upon these types of industry interactions and the pieces that from guidance from the regulators that you had mentioned, the compliance is always trying to update these, right? This is a new muscle that we're all learning to flex. So while the training may be what we have today, it's likely going to be different in the future as we're learning bigger and better practices. We as professionals are sharing ideas like this.
That's fantastic. All right, we're going to go on to our next hypothetical. Okay, Bernard returns to his office and looks at Dolores' account, and he discovers that last week she had liquidated 3 of her large fixed income positions totaling $400,000 with no explanation and no notification to Bernard, which was truly atypical behavior. In hindsight, while at Dolores' home, Bernard recalls seeing a brand new Mercedes AMG G65 SUV in the driveway, which certainly was not Dolores' style. Reflecting on this, Bernard realizes that Dolores has started to show gradual signs of aging and perhaps the onset of diminished capacity. There also is the possibility of elder abuse and undue influence. So in this situation, how should Bernard address these issues with Dolores' emergency contact? And I know, Maria, you started going into this a little bit. I mean, it is so hard to broach that communication. What are your thoughts?
Well, this suggests that the emergency contact already exists, so kudos to this advisor. But yes, that is the challenge. It's an uncomfortable communication to have, and from what I've read, they really sort of discourage having a conversation of even eliciting an emergency contact when something has already occurred. So the planning that you do up front is critical. But assuming that there has been an emergency contact provided, taking a look at the legal documentation and the language and verbiage of the emergency contact designation as well as the contractual provisions, I think could be a good security for the advisor on what we're allowed to share. Mm-hmm. And so, getting back to the form that I added into the materials for you all, the form that we are hoping to provide to our clients on a going forward basis actually does specify very clearly these are the situations under which we will communicate your emergency contact. It's not a power of attorney, and we will just use it to communicate as such, as we've specified herein. And you can change that person at any time, and we would be proactively looking maybe I would say at least on an annual basis, just to confirm that it still remains an appropriate person. And that is an important point because a lot of the statistics, depending on the studies that you look at, specify that a lot of the elderly abuse happens from trusted sources, family members, people that could be on this power of attorney. So those are yes?
So, you actually just took my question. What if you determine that the emergency contact is probably the person that's actually committing the abuse? So my real question is, hopefully you broach a subject with the client and they recognize things are happening to them, and part of your financial planning already covers this. But I guess the question I have is, practically speaking as the advisor, where sometimes you are the closest person, or maybe not the closest person to them personally, but certainly the one that they trust financially. Do you take on that power of attorney yourself? Do you become the trustee?
Yeah,
They don't have anybody, this comes up in the real world, right?
That's right.
They don't have anybody else, or they don't trust family, with their financial aspect and whatnot.
And I know a
They
lot of
come
people
to
are
you.
saying no, but I'll be honest with you, okay? There are some wealth managers out there, they have nobody else. And so the number one, I'm always gonna say this, okay, we're not providing legal advice here. Contact counsel in that unique situation where you've had that client for 30 years and they have nobody else except that trusted advisor. That is such a personal decision. So it's not that you can't do it, is that if you do it, there are so many regulatory obligations that you would need to fulfill, and that is a business decision, in my opinion. There's certainly a ton of regulatory considerations, so that should be the first thing. So I want to let you know, it's not that you can't, it's just you have to go into this with eyes wide open and a true awareness of what does this mean, and then be able to articulate that to the regulators when they come in to examine you. Okay, that's the number one thing. Lots of questions on this. Okay, I'm not even done answering, but go ahead.
I was just going to help on this. There are any number of firms that are private that serve solely as trustees with no affinity, desire, any other thing to get between you and your client in terms of managing assets.
Right.
They will serve as trustee. In those scenarios, we found it helpful to engage them early in the process such that there is a fallback for their business, which takes you off the hook of trying to make that decision.
And I agree. I used to be affiliated in-house at a trust company, and that's exactly what we did. So that's the second recommendation, is to see if there is an independent intermediary. That would be one of the explorations to take a look at, and I think that would solve many of your problems. The last consideration, and I think, and then I will go to the other questions, if you suspect that it is a family member, okay, that is the cause of this financial exploitation, which is, believe it or not, they're the second largest offender, okay? And they said maybe above that would be, people that are being exploited through the internet or social media and things of that nature, okay? You have to think about what is your fiduciary duty, okay, and what's the firm's position. If you're not in a state where it's required to be escalated to adult protective services or to the law enforcement, okay, and I can tell you personally, I've had clients that's exactly what they did. They reported it. I will also tell you the ramification of that was, and this is the scary part, the regulators then investigated them for potential abuse because they had been servicing this client for 30 years. That's the life example. They were that close with this client. They weren't a trustee, okay? But nevertheless, they themselves, even though they were trying to do the right thing, and I will end it there. But it ended positively for them. But nevertheless, it's one of the considerations that you have to think about as you're going through and reporting. Numerous questions in the back. Yes.
Theoretically, in such a situation, with no other option, if the person has a claim custody, why not just update ADV, go through the audit, and send in a letter saying, this is what I did?
Absolutely. So if everybody heard that, they said, why don't you just claim custody on Form ADV Part 1A and then go through the audit? Some firms just elect that they don't want the additional cost, expense, hassle, et cetera, that opening up Pandora's box to other things. These are all firm business determinations that you'd have to go through. Okay, yes, sir.
So do you think if you have a client that you believe has diminished capacity and is not capable of managing our affairs, would the investment advisor actually have an obligation to seek a guardianship or something like that? You know, and would it be a breach of the fiduciary duty not to do so under certain circumstances?
Okay, I'm going to open this up to the panel, so I'm not the only one to respond, but I certainly have an opinion. Anyone?
I'll let you take it.
Okay.
Yeah, legally, you can take it.
Yeah, whether or not you have to appoint a guardian, that's actually in my client's scenario, that's exactly what they did. They had a conservator that was appointed to do that because they felt that that was part of their obligation. And I have heard a lot of dialogue of, there's a fine line between we're a financial advisor, we don't want to go into the caregiving business. But the reality is, in many instances, okay, you're the only person that they know. Okay, and perhaps, it depends on that facts and circumstances of that client, but their family could be turning to you and saying, I just don't know what to do. And at the end of the presentation, the very last slide, we actually have a resource that you can go to. And NASA, if you click on your state, actually gives you the contact information for Adult Protective Services, the contact information for local law enforcement. There's also a series, I know that the IAA, when we did that webinar, there were a series of resources that were provided with regards to who you could reach out to even for as a caregiver, and that would liaise with the family and try to get through these difficult and challenging times. So that it's really, are you obligated to do it? No, I think it goes to the firm culture and what you need to do, and as an entire enterprise, you should be coming together and saying, that's the tough question, what are we going to do in this circumstance, because it will come up.
Well, but if you don't do that, then I would think your only other option is to drop them as a client, because if you continue to represent them, that would surely be malpractice.
Or you put in the contract, this is what we will do and this is what we will not do. Okay, yes, sir.
They can't sign the contract. They
Well-
can't re-sign the contract.
Well, no, I'm saying before, you would do this at the account opening of what we would do. I'm talking about, and that's really going to Maria's form that she put together.
Michelle,
Yes,
I'm with IAA.
of course.
And I worked with you and on that webinar that IAA did, and for members, it is accessible on our website. Maria, thank you for mentioning it. Just 3 quick points. One you alluded to. There are geriatric social workers. If you do not know how to communicate with your client, and it's not easy, there are folks that are trained professionals who can help you doing that. Those are geriatric social workers. Secondly, I think the fact pattern, which is terrific, and the notion that the emergency contact is perhaps the family member who is exploiting your client. I think that points out the importance of the power of attorney provision. So there is an individual who does have a fiduciary obligation to that client. And then finally, just a quick footnote. For better or worse, I was an advisor to the NASA committee that came up with that model law that was alluded to. In its earlier iteration, and one that we supported, it would have provided you with a safe harbor.
Yeah.
In the event that you reported to the Adult Protective Services Agency in your state, and in the very situation that Michelle mentioned, where then that agency was investigating the advisor. Well, the original intent of the NASA model law was to provide a safe harbor. So you would not, so there would no longer be a disincentive for you to make a report. In the 12th hour, NASA turned it around and created a situation where there is liability if you do not make that report. We certainly did not support that change, but I just wanted you to know that originally the intent was simply to remove the disincentive so you could make that report. But the middle ground, I believe, is reaching out. Well, one is the power of attorney, and secondly, reaching out to a geriatric social worker.
Excuse me, what happens if you believe the person with the power of attorney is the person
Yep.
abusing
It's good.
Well, I'll let some of the folks on the panel address that. In that situation, clearly that individual is not fulfilling their fiduciary obligations, and themselves is vulnerable to enormous liability. Whether you then reach out to other members of the family, that's a difficult call.
Yeah, and I've actually had a situation that was part of a scenario that came up, and I don't want to disclose necessarily what the firm did for breach of attorney-client privilege, but I will tell you that they did not sit idly. They did take action to go forward with, let's just say, escalation procedures to law enforcement. I think that it is such a tough situation because a lot of time those folks with POA obviously they are the emergency contact and everything else. It happens to be a son, a daughter, or in this case, perhaps it is Arnold, right, that gets that POA. And what do you do in that situation? And that's very, very tough. So, absent, taking a legal position and going to a court, perhaps, okay, and having further investigation, that remains intact. Okay, so that's where it's important to think about, and perhaps it's not the advisor reporting this to Adult Protective Services, but it's the family. And then, that brings up the whole, well, what about Regulation SP, and am I breaching that? This form that Maria gave you as a sample is excellent. And what it really, I encourage you to take a look at it, because what it really discusses, and this is focused on diminished client capacity, it include financial exploitation in this. And say, this is the person that has a power of attorney. And here's the hard part. Do we put, in the event that this person is unavailable, okay, is there somebody else? That's what this dialogue is really bringing up today. It's that old adage, right? Trust but verify. We've got to make sure that the folks that we're dealing with are doing the right thing. There are two.
Sharon, I just wanted to add one thing and perhaps turn the temperature up just a bit on these decisions and just make you aware of another dimension, and that is affinity fraud, right? You've all heard about it, but in this case, whether it's dealing with an advisor who is part of the same religious organization or for military personnel, that type of thing, the decisions are going to be all that much tougher, especially in that situation where the POA is suspected. And it has internal sort of political and risk internal considerations as well as outside, right, in that affinity group. So that's just another consideration. It's another dimension that you'll likely have to address at some point and be ready for those discussions about what types of risks the firm wants to take on and how quickly they want to move it up the chain to resolve it.
And I think all of the discussion, what this has just proven is that you can have the best internal processes, documentation, procedures, but you really have to handle it all on a case-by-case basis because there's so many nuances to every single client that you have. And that the process of escalating it also early to your legal, to your compliance personnel within the firm, you're not in this to do it alone. You have other people who are there to assist you. So just always keep that in mind. So put the processes in place, but know that it's always going to be a one-off, a one-by-one, and you handle it accordingly.
And I just want to throw out, there were some excellent questions that came through. I'm going to address two of them, and if there's time, we'll go back to some of the others. This is for the panel, and I'm just curious about this. In this scenario, do you need a doctor's assessment of capacity in order to not take instruction for a withdrawal or disbursement?
That's a good question. Not sure about that, actually. I think that you're saying to report at that point. To
know if you're going to take, let's say you have a wire instruction from the client and they would like to withdraw additional funds. The question is, do you need a doctor's assessment to say, no, we're not going to do that?
No, I would say no at all. I mean, I think when you're looking at it, you know your client. You've had the client a long time. You know their patterns. You've looked at their withdrawals and so on. That if you see that you think that there's something a little askew, until you're very clear that there is no outside influence, and especially under the NASA rule that we have there now, where you do have 15 days, I would err, you are their fiduciary. I would err this on the side of being safe and saying, let me get a little bit more information before I do honor that withdrawal.
Okay, yeah, and that really goes into documenting, looking at the facts and circumstances, and most importantly, it is, do you have a reasonable belief? That's the key words that they use. So it's not just that this is atypical behavior. You've gone to their home, you've seen Dolores' condition, you're seeing that she's not herself, and that there are a series of events that have led you to make this decision. Yes, sir?
Yeah, I mean, in this case, Dolores doesn't need you to withdraw funds, obviously. I mean, she's doing it, you know, quite effectively on her
Yes.
own. To what extent do you have an obligation to shut down her access to her account?
Yes, and that is a wonderful question, and I think that, you know, it's through your investigation you would contact, and this is under the model rule, you know, they're saying, look, if for whatever reason you're not going to act on an instruction, you're absolutely right, she could go into her account, and the question is, am I going to freeze her account, okay? Could
Who do
you
talk to do that?
contact the custodian? You would instruct it. And I agree with that. Yeah, but I can tell you in one case that I have had, they agreed because in this case, okay, the perpetrator was going to the bank. Okay, it was an interesting scenario. Going to the bank with the client, clear financial exploitation, and this individual was trying to withdraw the funds. She was standing next to him, but he was trying to withdraw the funds. And they contacted the advisor and they said, we're freezing her account, we're letting you know, and they actually try to collaborate together. Okay, so it can happen, but it's clearly facts and circumstances. Yes, ma'am?
Yeah, so in this kind of situation, when you use an outside custodian, who's the onus really on to detect this and
You know, the question is, you know, even if you contacted the custodian, you could say, look, we're not going to follow that instruction to withdraw. Let's say it was an instruction, because there's two scenarios. The client going about and doing and withdrawing their own funds, which is very difficult to control, okay? Or the scenario whereby the client is instructing you to withdraw the funds. In the latter case, it's much easier, and what your fiduciary obligation is to let them know we're delaying the disbursement of fund for whatever period of time, up to 15 days, okay? And then you would trigger, if there is an emergency contact in place, contacting either that person with the POA or the emergency contact, and trying to conduct your own internal review, your internal investigation. If all of your fears are alleviated, then of course disperse the funds. If they're not, then the question is, do we at this point escalate this to Adult Protective Services and law enforcement, whereupon they can decide whether or not they want to extend that period of time for not dispersing funds up to 25 days. And let's just say, and I'm going to throw this out, this is horrible that I'm even creating my own question. What if you come to that 25th day and there's no resolution? Do you disperse the funds or not? Okay, and according to the model rule, you should, okay, after the 25th day. Okay, and then the question is, with the person with the POA or the emergency contact, they should be working with, okay, law enforcement to determine what is the next steps that we need to take. Maybe they are going to appoint a conservator, okay, or that independent party to take over as a fiduciary that account. And as an advisor, you have a determination. The other thing you could do is, as harsh as it sounds, you have the option of terminating the client account. And in some cases, that will be the decision. Yes?
So if you are like in your investigation period, are you required to contact the custodian and say, we're investigating this if the client comes to you to withdraw funds herself?
That is correct.
Like,
That you would go, well, you're not complying with the instruction. If the client decides to circumvent you and go to the custodian, it is very important, I think, in any scenario to have clear communication so that they can have a note on the file that this is what's happening. We're suspecting that because, again, if they happen to be, you know, they might be a broker-dealer custodian, they might not have a fiduciary standard, but they still need to be looking at the client's best interest. And I think that then gets escalated to their legal compliance department, and they determine as to what actions, if anything, they should take.
And that's why it's also important internally that you have your processes in place, that when you suspect something like this, that you have an alert within your firm itself to say, all requests that come in from this client must be directed to this point person, because you don't want them circumventing you and going to somebody else. So this way they come to you, you then decide, and working with compliance, take the appropriate measures.
Yes.
I'm hacking into your model here.
Okay,
but-
good.
Because clearly, just thinking through this, the woman knew the 3 fixed income securities she was going to liquidate to get to this. So there's a mental faculty that's still working in there.
Well, was it
Possibly.
her or was it
that's where you're gonna get to
Yep.
that. But when you get to the point of them circumventing the IA and going to the custodian, we all have relationships with the custodian whereby if they're gonna withdraw funds and the custodian gets a phone call to say, withdraw my funds, the first thing the custodian is gonna do is call
Call you.
the advisor. And so, where is it on the hook legally that the custodian just says, forget that, I'm just gonna honor the request? Versus contacting the introducing advisor?
Yeah, and I think honestly, it's gonna be based upon their standard operating procedures. And that's what, and so, you know, it's going to differ firm to firm. I can tell you from my own personal experience of dealing with this situation with clients, they will contact the advisor. They usually work in concert to the extent they can, because they really are trying to look out for this individual. It's a question of, have they had the same type of experiences with this individual as the advisor? Typically, you have a closer relationship, more interaction, and more firsthand
So
knowledge.
you wouldn't see a custodian just take the request generally and honor it,
They would contact you, generally.
generally.
I would suggest that most of the major custodians view the client as their direct client.
Correct.
This is
And
the
and
gray
that the
area.
client has provided limited authorization to the advisor to do
For
certain
purposes of,
things.
yep.
And we're usually the interface, but again, the custodian views that person as their client. If they get an instruction, they're gonna process it. If they don't,
Because for all they
Have
know,
a
they're
red flag.
withdrawing it to go to a different advisor.
So in that, so the concern that I'm getting at, which you're illustrating it well, is that, in effect, you're out of the loop at that point in time.
And a lot of times, that is for that very reason where you can no longer, because the client's putting you in that position, you can no longer be their fiduciary because they are taking you out of the loop, that many times the communications go something to this effect. At this point, we have no choice but to terminate our relationship because you no longer are involving me as your fiduciary. Okay? All right, anything else? Yes?
I have a different type of question. Since we didn't write this into our contracts of the 900 clients we already have, and older people are very sensitive about any suggestion that they might suffer diminished capacity, how are you, Maria, how are you introducing this now to your existing clients? Because I assume you're trying to also get them to give you this kind of information.
Absolutely. So actually, in 2016, one of the other key actions that we took was to draft a newsletter to all of our clients.
It's in your materials.
It's in your materials. I
Brilliant.
hope you can find it helpful. And what we did there is not only explain the various sources of financial abuse or fraud or diminished, we actually explained, we gave them examples of the main culprits as well as some clear guidance as to how they can protect themselves, such as, for example, email fraud, from the fraud or abuse that can occur from caregivers and other service providers that are in an individual's house on a regular basis, from the perspective of, and this is the toughest part to address really, is the known offenders, meaning the people that have the power of attorney, the people that can forge checks, that can forge your signature, and we gave them some guidance around that as well. Separately, we sensitized them to what is diminished capacity, what to look out for. We concluded by giving them some advice. So, for example, organize yourself, all your key documents, all your accounts. And we have a tool that our clients actually showed a lot of interest in. It's called a personal document locator, very comprehensive. And we encourage them to centralize this information for safekeeping, but also to engage to start to think about engaging a trusted person to also know where this information resides. We did encourage them to provide it to us as their financial advisor. As the panel has pointed out, and you all know, a lot of our relationships are actually long-term relationships that we know inside and out. And that helps us actually with the monitoring of the activity, but we need their help in having the information up front. And one of the other things, I think we talked a little bit about different types of power of attorneys that they could leverage to protect themselves. And finally, encourage them to give us a list of your professionals, your key professionals, your attorneys, your accountants, because we do know them and we can triage better if we have all that information up front.
Maria, what was the response? What kind of response did you get back from your clients?
The most interesting was asking us, that's a great tool, can we take a look at, can you give us a copy of your personal document locator? Which, sources, account numbers, passwords, websites, property documents, legal documents. And that, I think, is great because it starts them thinking already, okay, I need to have all this information. It is a bigger task than I thought to gather. And then separately I think it's at least it will start them to think, I do need to protect myself. I do need to identify an emergency contact. I really wanted the clients to contact us and just say, here's the signed document with my emergency contact in the event of diminished capacity and financial manipulation, but we're hoping to get there at some point, and yes.
Follow up then personally, like in client meetings, have the
Yes,
counselor follow up?
I think that's the plan. We have wealth advisors, financial planners, and the investment team contacting the clients on an ongoing basis, meeting with them, and bringing up those sensitive topics. Even in connection with the wealth planning initiative, talks about estate planning and things of that nature, helps cash flow needs. All the communications that we're having with our clients allow us to learn and understand them so that we can better monitor when there might be concerns.
Okay, one question and then we've got to move on. Yes, sir.
About the other professionals that the client may have, like accountants or lawyer, whatever, what would be our obligations for doing due diligence for those particular people? Like a client says, I no longer can handle my personal day-to-day affairs, I want you to contact directly with my accountant, if they ask for transfers, do that, they'll pay my bills. What are our requirements for doing due diligence on that accountant to find out if this accountant is legit?
Anybody? Okay. I think the key is, okay, if this is someone the investment advisor is recommending, then you have an obligation to do due diligence. If this is somebody that the client has selected, I mean, you could certainly do a quick Google search and see if there's any kind of disciplinary action for that individual, but it's not necessarily your obligation to conduct due diligence on that service provider. It's not one of yours. It's not somebody you're recommending to service that client's account.
Something went flooch, and somebody said that this was all wrong, this guy is a crook or something, why are you sending him money? We got the client's okay to do so and everything. Should we have gone further in that case?
Yeah, and it's going to be facts and circumstances based, and I think that the number one thing is, if at the time when they're instructing you to do it, they are not, you have a good faith, reasonable belief that they're not suffering from diminished capacity, fine. If you believe that they could be having some traits where there could be a potential indication of such, that's where you would trigger the POA, the emergency contact, and hopefully, if needed, another intermediary.
The other thing to keep in mind is we have clients that are long-term clients, and you've been dealing with their accountants or with their attorneys over the course of the time that they've been your clients. If all of a sudden you see that there is a new, attorney or accountant being introduced, you may want to do a little bit more fact-finding to find out why the change. Was it due to a death? Was it due to retirement? What was the reason?
And I'm going to ask the panel this generally. We've covered a lot of ground, okay? But this question came up, and this is in the hypothetical, the second to last question. In looking at Dolores's client file, Bernard is searching any documentation as to whether or not Dolores notified him of a power of attorney or emergency contact, and unfortunately can't find anything. In this situation, and this was one of the questions posed, what if I don't have an emergency contact? What in this case should Bernard do?
Okay. So I would imagine that depending on the stage at which, the financial exploitation is, and how we have the Senior Safe Act that I know is still in flux, but nonetheless, in there are protections I think the main gist there is to protect the advisor from repercussions when they're acting based on reasonable beliefs that their client, might be either being manipulated or exploited or being influenced to take actions that are contrary to their best interests. So in that scenario, I would imagine that if, fortunately, we have other family members, other than Arnold, I would think at that point, depending on how our due diligence has pointed to the fact that there exists exploitation, that we can probably report it to the authorities, maybe the Adult Protection Services, maybe talk with off-counsel as to proper steps before doing that. And potentially in the contract language that I think, I'm not sure if it's in the IAA's model agreement, because I think the language that they have was very instrumental to what we created in our contracts. We actually built in some protections in there in terms of steps that we can take, independent of whether we have an emergency client contact, such as, for example, not acting on a request for withdrawal for a period of time that is not really tying back to the Model Act, but to the contractual provisions that the client agreed on, if there are any.
I think Neil's got.
Neil?
Neil Simon again. I would just point out the Senior Safe Act, a piece of legislation that IA supports, although it passed the House in the last Congress, did not pass the Senate. So we're starting the process anew.
Again.
And this would provide a safe harbor for financial service providers who suspect elder abuse when they report it to authorities. So it's good policy. But it is not yet law, so you can't rely on it.
Right.
So come back to town on June 7th when we're having our lobbying day, because that's going to be one of the things that we're storm Capitol Hill to support.
Yeah, and that was actually included within your materials if you would like to take a look. Sharon.
But this is where it's very important. We've been talking about all of these different issues and all of these different maybe things that we are recognizing. It is very important that you document every step of the way, every step that you've taken, the who, what, where, when, and why. You want to be the Joe Friday, okay? Because if the time does come that you have to escalate this to an agency, to your compliance department, et cetera, you want to be sure that you have your sound basis, you have the facts. When did it happen? Who did I speak with? What did I observe? You don't want to leave it to your recollection as to, I think it was 6 months ago, maybe it was really only 2 months ago. So documented, we always suggest putting it into our CRM system on the contact database. This way, everybody in the firm can look to see what the history is, to see what concerns that you have, and if they maybe were not in the day that the order was given, please send everything to the financial advisor, they can look and see the history that is there. So document, document, document. They always say the SEC says, if it's not there, it didn't happen. So make sure that you do that, you follow that.
Okay, we have approximately 4 minutes left. I'm not going to accept any additional questions, so we can give you the last snippet of really important information, okay? The next question was, how might compliance advise its advisors on steps to take during account opening? Maria mentioned it. I'm going to advocate for this, okay? This was, within your materials, there is an amendment to the Investment Advisory Agreement, which was the model contract that the IAA has for its members. It's in your material. There's also the actual contract in its totality, in and of itself in there. And we had a working group, and we worked on the specific language that you and your firms may wish to consider to deal with this really tough issue. And to Maria's point, it talks about what kind of client information you're going to be safeguarding. It'll talk about life-changing, significant life events. Okay, so in the event there is death or incapacity, it lumps all those different significant life events. That's a little bit more appetizing than just saying it's diminished capacity, right? It talks about termination upon proper notice and what the steps would be. It then covers disclosure of client exploitation, letting them know we will escalate this to law enforcement and adult protective services, and then withholding of distributions upon reasonable belief of client exploitation. It's all in there. Because the hardest thing that you have and your challenges, for some of you that might have legacy agreements that haven't been looked at for 10 years, it doesn't likely cover this. okay? Our client base is evolving year by year, and we know we're getting more and more demographics of aging clients. So we've got to now think about our business models. This will protect yourself from a legal basis so that a client, and their, especially the beneficiaries, won't come back and say, you weren't actively managing mom and dad's account, okay?
What do you do if you already have a large client base?
Okay, I'm gonna hold that, because I said no questions, because we gotta get
I'm
through.
just saying, how do you?
Mike, I know, I understand what you're saying. If you have a large client base, how am I going to deal with this phenomenon of all the clients? That's why the IAA provided an amendment to the contract. See, you can always do a mass mailing, see if they'll sign that amendment. It's only those sections that would be an additional provision to the contract. So that might be one way of looking at it, okay? Last but not least, going around the circle, Sharon, we've got, compliance is doing their investigation. They find out, that unfortunately it looks like Arnold's exploiting Dolores. She's calling Bernard and requests a withdrawal of $200,000, and then, we hear that Dolores is being influenced in the background, and sure enough, it's Bernard, and he's saying, is there anybody there with you? And she says, yes, it's my dear friend, it's Arnold. So, this is the situation we've been talking about. What do we do if they're going to sell position, and what obligation, if anything, does compliance have to report this to authorities? From a practical standpoint, knowing that's a lot to cover, what has your firm taken as far as setting up those standard operating procedures to address these type of situations?
In this instance, obviously, we would not sell those positions because we feel that we have some knowledge that there could be something nefarious going on. So I would tell people within our firm, you escalate it right away to your compliance department, okay? Get them engaged in it so that they can do any kind of legal or compliance investigation that needs to get done. You do have that 15-day safe harbor where you don't have to do anything if you believe that there is anything that is wrong. I would say that this is where training really, really does come into place for all of your employees. Train them to know how to handle situations like this. As we said, you can have the best processes in place, but if they're not followed, okay, if it's not escalated, and escalate it early. Don't wait until you're halfway down, the ball field and then find, you know what, I should have checked the play with the coach before I did this, So do that early, document it all, as I said. Review all of your documents and your agreements to make sure that you do have these kinds of items in place. We had a case where we did do everything that Maria said. We had everything in place, so it worked for us wonderfully. We have a client. She always had her children in on all of her periodic annual reviews. Well, one day, they looked at her credit card statement and found out that there was a charge card for a lawyer. They looked up the lawyer, found out it was a local lawyer, and they called and they asked her and said, Mom, what's this all about? She had a gentleman friend, okay, who then said, oh, he took me down to see this lawyer so that I could get my estate in place. Okay? Now, she had already had documents in place. We had the lawyer on file. So the children called us up and said, how do we handle it? So what we did is we sent a letter to this attorney and we said, oh, we understand we have a mutual client. She already has an attorney who is handling her legal documents, in fact, is continuing to do so, and please send us a bill for any services that you may have rendered that she has not paid for. We have not heard from the attorney since, okay? So it was handled discretionarily, discreetly, but the active involvement of the POAs or the other contacts in place, in this case, did protect our client. So if you can do that as soon as possible in the relationship, you may get hindrance from the client. Again, elder people, how dare my children are going to take my money away from me, or how dare you think that I don't have the ability to do it. But you nurture them along as you go through the relationship. And hopefully you're not reaching when they're 70 years old. You've been getting it earlier on.
And to that point, I want to share that Sharon provided, okay, that 13% of firms that had escalation procedures, she's one of them, okay? And that's in your materials. They're absolutely brilliant. I know that we're out of time. I'm going to turn to the panel for just, if anybody has a snippet, you have 20 seconds. Last final thoughts.
Document at the onset of the relationship.
Sharon?
Just training, documentation, and engage the people that you need to help you in the relationship.
John?
I'd say tailor, document, and follow through, and in tailor, I mean, we all have different size firms. Tailor these principles to you and what works for you, and then follow through on them is most
Yeah,
important.
and finally, look at those contracts, amend them, really look at the resources provided, and I can't thank the panelists enough and for you for your active participation. Thank you.